Thank you, gentlemen, for being here, and thank you for your service. I have a question for Director Klapper and one for Director Alexander. Director Klapper, under the National Security Act of 1947, the intelligence community is required to keep Congress informed, the Intelligence Committee is informed of significant intelligence activities. Without confirming or denying the most recent press reports of eavesdropping on the leaders of allied countries, would you consider a wiretap on the leader of an allied country to be a significant intelligence activity required to be reported to the Intelligence Committee?
In the context of what we try to keep the Congress informed on, in the totality of what we are charged to do in the NIPF, and in what we submit in our congressional justification books, we think, we've by and large met complied with the spirit and the intent of the law. It's not to say we couldn't do more. I have put a lot of emphasis on written congressional notifications to the Congress. I've been in this job, and I think the statistics would bear that out. The fact that we don't necessarily report each and every selector, and that we're dependent on the general rubric of leadership intentions, I guess that's something we could discuss as to whether that level of detail is required in the form of congressional notification. But I believe, and I have striven to make this happen, that we have lived up to the letter and spirit of that requirement.
Director, I'm not perfectly sure what to make of that answer. I think that if you're tapping the phone line of a foreign leader, an ally, that is a significant intelligence activity that should be reported to the committee. And I don't mean reported in general terms. In other words, telling the committee, and I'm not saying this is the case, but if you were to tell the committee that you have high confidence that this country, Germany or France or another, would continue its troop commitment in Afghanistan after a certain date, but you don't tell us why you have that high confidence, I wouldn't consider that informing us of something that is a very significant intelligence activity. And I would certainly think an intelligence activity that we undertake that has the potential for the kind of blowback we're seeing today would be something that you would want to report in considerable detail to the committee.
Well, sir, there are many things we do in intelligence that, if revealed, would have the potential for all kinds of blowback.
I don't doubt that, but those are exactly the things that should be reported to the committee, because it's a policy decision ultimately for us to make. Is it worth the risk? Is it worth the risk of that blowback in light of the information that we gather? So I think we have a lot more work to do with you to make sure that we're getting the information we need.
Well, the conduct of intelligence is premised on the notion that we can do it secretly, and we don't count on it being revealed in the newspaper. So that would change the criterion, obviously. And if what we embark on in the way of a collection activity, because of its potential blowback, if revealed publicly, that's a higher threshold, or a lower one, I guess, for providing more notification.
Well, I find it very hard to understand why, if this information was deemed too sensitive to be shared with the Intelligence Committee, it was not so sensitive that it wasn't accessible to a low-level systems analyst like Mr. Snowden. That makes no sense to me whatsoever. Director Alexander, if I could ask you on the metadata program, if you believe that this can be done technologically, that is, move the data to the telecommunications providers, allow them to retain their data, and we can get all the information we need when we have a need to get it, why not undertake that now on your own? Why wait for legislation to require it? Why not go to the FISA court order and say we're going to request instead a program in which we go to the communications providers with a particular number, with a selector, when we have reason to believe it's connected to a plot? And why not announce to the country, we hear you, we're making this restructuring, we can get the information we need, and we can do so in a way that's more protective of the privacy concerns that have been raised?
So the issue would be in working there right now, and I would ask Mr. Cole to make sure I answer this exactly right, but right now, in terms of, we would have to have a change in statute in order for them to leave at the service provider. So that's where you come in. We couldn't compel them or get them to keep this data, and the courts could not do that. As I understand it with this, did I get that exactly right?
That would be correct. There's no statutory requirement for them to keep it for the length of time that we're looking at, be it either 3 years or 5 years, and we would have to have that as a separate piece of legislation to give us that kind of longevity confidence.
I'm out of time. Thank you, Mr. Chairman.
And I just want to clarify the record on this, that this committee is briefed on the National Intelligence Priority Framework and its changes, those ongoing changes. And as an example, the NSA has, in the last 3 years, 292 different occasions, been a part and engaged by this committee, both members, staff, or both. We go through this through our budget planning, which is extremely thorough, which also, in our classified annex, talks about activities that are sensitive to the national security of the United States. All of the products of the intelligence community, of which we are consumers, are available to the committee. Sources and methods, unlike any other committee here in this Congress, are available to this committee. I would argue to make the case that somehow we are in the dark is mystifying to me. Some members spend a lot more time on this committee than others based on their schedules, which are significant in this Congress. But it is disingenuous to imply that this committee did not have a full and complete understanding of activities of the intelligence community as was directed under the National Intelligence Priority Framework to include sources and methods.
Will the Chairman yield?
I would yield.
Mr. Chairman, are you suggesting that you and the committee were informed of the wiretapping of foreign leaders, if that report is correct?
Well, I wouldn't confirm any specific of the intelligence community, but as the gentleman knows, as I have highlighted, that we have access to all sources and methods, and there is lots of product to be reviewed by the Intelligence Committee, through the Intelligence Committee and through the members of the committee. And any implication that through those reviews that this committee would not be informed to the status that has been in question is not correct.
Well, I'd be interested to know, Mr. Chairman.
We would be happy to take you down to the committee and spend a couple of hours going through mounds of product that would allow a member to be as informed as a member wishes to be on sources and methods and all activities of the intelligence community under the National Intelligence Framework.
Well, I would just say, and
I just think we need to be careful about what you're talking about, but I think it's disingenuous to use the classification.
Well, and I think it would be disingenuous, Mr. Chairman, if you're suggesting we have information if we don't have it. So I would like to find out just what we were informed by the Intelligence Committee, and I would also like to find out if this is in the posture that you sometimes see in litigation where you're given a warehouse full of documents.
Well, again, reclaiming my time. This is a very unique committee on Capitol Hill. And it's the only committee on both sides of the chamber that has both military and civilian intelligence activities. That is an enormous responsibility for every member of this committee. Enormous. We don't get to take personal staff from our offices to assist in any of the processing of information that we may have to do as members of this committee. But I think it is to the semantics of exactly who, what, when, or why. If you're asking if the Intelligence Committee submits a selector, or excuse me, the intelligence community submits a selector to every engagement to the Intelligence Committee, that would be ridiculous. And no one would receive information in that way. Not even the Director of National Intelligence would receive it in that particular way. But to know what the framework is and know what the guidelines are and know what the reporting is and go through the very significant oversight of this committee and the review of the product, which is incredibly important to the end, and to say that this committee is somehow in the dark on intelligence activities is just as simply as not accurate. And I think we need to be incredibly careful about making any assertions that somehow we're in the dark because that information is available in robust amounts of material in our particular committee. It is time-consuming. I get it. It's a very time-consuming committee. But I think, again, this feeds into this flame of misreporting about lack of oversight, or that the committee, our intelligence community is running around doing what they want to do outside of the law or any oversight, is wrong. And I just caution members, before you might make any statement to the contrary, I would argue that a significant portion of your time should be spent in the committee reviewing the materials available and made available by the Intelligence Committee in accordance with the law, of which we are charged to do. And with that,
Mr. Chairman,
Ms. Bachmann. No, reclaiming my time, I will not. Ms. Bachmann.
Mr. Chairman.